Welcome. Today, let us learn the concept of good conduct time allowance. There are two types of prisoners. 1. Detention prisoners. 2. Convicted prisoners. Detention prisoner is an accused who is under detention although the criminal case filed against him is still pending or on appeal. Although a detention prisoner is not yet convicted by final judgment, he will remain under detention if he cannot afford to post bail or the crime with which he is charged is non-bailable. The detention of a detention prisoner is called preventive imprisonment. A convicted prisoner is a person who has undergone trial and who has been convicted by a final judgment by a court of law or tribunal for the felony or offense he committed. A convicted prisoner is entitled to a good conduct time allowance under Article 97 of the Revised Penal Code for good behavior during detention. For example, a convicted prisoner is sentenced to suffer 10 months of prison correctional for committing serious physical injuries. Under Article 97 of the Revised Penal Code as amended by GCTA law or RA number 10592, during the first 2 years of imprisonment, he convicted prisoner shall be allowed a deduction of 20 days for each month of good behavior during detention. After serving 6 months in jail, the warden of the city jail granted him a good conduct time allowance of 120 days or 4 months. Because of the good conduct time allowance, his sentence of 10 months of imprisonment will be considered served out, although he was only imprisoned for 6 months. Before the good conduct time allowance law or RA number 10592, a detention prisoner is not entitled to good conduct time allowance. However, RA number 10592 now grants good conduct time allowance to a detention prisoner. Section 4. Article 98 of the same Act is hereby further amended to read as follows. This article shall apply to any prisoner, whether undergoing preventive imprisonment or serving sentence. Under Articles 29 of the Revised Penal Code, as amended by RA number 10592, whenever an accused has undergone preventive imprisonment for a period equal to the possible maximum imprisonment of the offense charged, he shall be released immediately for purposes of immediate release. The computation of preventive imprisonment shall be the actual period of detention with good conduct time allowance. Example, a detention prisoner is charged with less serious physical injuries, which is punishable by arresto maior, 1 month and 1 day to 6 months. After undergoing 4 months of preventive imprisonment, the warden granted him good conduct time allowance of 80 days or 2 months and 20 days. Because of the good conduct time allowance, his period of preventive imprisonment will be considered 6 months and 20 days, although his actual detention is only 4 months. Since the period of his preventive imprisonment, 6 months and 20 days, is more than the possible maximum imprisonment, 6 months, of the offense charged, he shall be released immediately. In GR number 249027 and GR number 249155, Ginto et al. Versus DOJ, inmates of New Bilibid Prison et al. Versus DOJ, SCN Bank found that the DOJ, in enacting its 2019 IRR, exceeded its power of subordinate legislation when it excluded persons convicted of heinous crimes from the benefits of RA number 10592. RA number 10592, amending Article 97 of the RPC, used the connecting conjunction or to express that 1. Any offender qualified for credit imprisonment pursuant to Article 29 of the RPC, and in the alternative 2, any convicted prisoner in any penal institution, rehabilitation, or detention center in any other local jail may avail of the benefits granted by RA number 10592. Thus, detention prisoners and convicted prisoners who are recidivists, habitual delinquents, escapees, or charged with heinous crimes are excluded from the beneficial coverage of RA number 10592 on good conduct time allowance.